on Law of Thought of Negligence. Today, we'll analyze a real-world case involving Miss Laila, a pianist who suffered a serious injury due to careless renovation practices. We will walk you on background, legal analysis using 4 elements of negligence. We will also propose a recommendation on how Miss Laila proceed her claim. Thank you for coming. As you know, we have decided to proceed the renovation of the law apartment, and we review your proposal and are ready to sign the contract as the advised.
Thank you. My team and I are honored to have taken upon this contract.
Alright, the contract, as you can see, the contract does not include any exemption clauses. That means SRS the MBHD cannot limit or exclude liability for negligence, especially if it causes injury or damage. Do you agree?
Yes, I agree, and my team and I are fully capable.
Perfect, and let's proceed to sign. Alright, we'll keep a close line of communication throughout the project, and you may go down. Oh, my hand.
Come in. So, you must be Miss Laila. What brings you in here today?
So, I'm here to claim compensation for accident that happened to me. If the employee not negligent, I wouldn't been hit. That's why they call it factual causation. And was it foreseeable? Of course, anyone could see that tools could fall on a pedestrian. I am pianist. This hands was my life. Now, I can't earn any income because of injury that happened to me.
Miss Laila, I am well aware of the difficulty and tough times that you are going through right now. Firstly, I want to make sure that you are aware of your legal situation. Specifically, we need to talk about negligence and how it might be applied to your case. Negligence is one of the most common types of personal injury claims. It is important to break it down in elements that we need to prove in court, such as...
So based on the slide, duty of care is the first essential element that must be proven for a successful claim. It is defined as the responsibility to act cautiously in order to avoid others by getting hurt by our action or by failing an act. The law expects us to behave the way any reasonable person would be in the same situation. By failing to this act and leading to another misfortune, they can be held legally responsible for the harm that was caused.
Breach of duty. It occurs when a person or an organization that was owed duty of care failed to meet the standard of care expected in a given situation. They acted in a way or seemingly failed to act that a reasonable person would not have, leading to a failure that puts others at risk of harm. To determine whether this breach has happened, the court looks at what the reasonable person would have done under the same circumstances and compares it to what the defendant actually did in that situation. Bolam v. Freedom, Hospital Management Committee, 1957, 1 WLR 582, Valentine 2019.
Causation refers to the connection between the defendant's breach of duty and the harm suffered by the claimant. In other words, it must be proven that the defendant's action or the failure to act caused an injury or harm towards the claimant. There are two parts to establishing causation. The first one being factual causation using the but-for test. Would the harm have occurred but for the defendant's breach? If the answer is no, then factual causation did occur. Legal causation is the second one, also known as the remoteness of damage. considers whether the harm was a foreseeable result of the breach. If the damage was too unexpected or indirect, the defendant might not be held liable.
In negligence law, damage refers to the actual harm or loss that the victim suffered, be it physical injury, emotional distress, or financial loss. This harm must be real and proven, and not just a potential risk. Once damages are established, the defendant may be held liable, meaning they are legally responsible for causing that harm. When all four elements such as duty of care, breach, causation, and damage are proven, the court can order the defendant to pay compensation. The goal of damage is to return the injured person as closely as possible to the position they were in before the accident occurred.
So, to sum it up, we have to show that the defendant had a duty and has breached it and caused the pedestrian such damages and injuries. But don't worry, I will reach out to you as soon as possible before we meet in court. Thank you.
I will rise at the side. A reasonable contractor would have checked the scaffolding, secured the tools, and warned the public.
This is the result of the site investigation. I found that the scaffolding had failed, the tools were not secured, the workers did not put out any warning signs, and also they also are not aware of their surroundings.
Well, thank you very much. This has proven all of the breach of duty criteria. Thank you for your help. I appreciate it.
Order!
I am not at fault, since the contract specifically said that there are no exemption clause.
So, the first element that is proven is duty of care. Did the construction company owe Miss Layla a duty? Absolutely. Like the case of Donahue v. Stevenson, it is made clear that we should not harm our neighbors or the people foreseeably affected by our actions. Secondly, breach of duty. If the scaffolding hadn't failed and the worker had not been negligent, then Miss Layla would not suffer a tremendous loss of income as well as miserable and painful sufferings. This so-called disclaimer is meaningless because Miss Layla had not signed any contracts. She's a third party, and that made her a non-contractual disclaimer. So, we've heard the story, we've seen the harm. Therefore, under the law of tort of negligence, Miss Layla should be able to seek justice and compensation for her medical treatment, loss of future income, as well as pain and suffering. Who is liable? SRSD and BHD as the direct wrongdoers. However, Delta Construction Company is also at fault since they are the property owner. They hired SRSD and BHD and they left SRSD and BHD unsupervised. Thank you.
Negligence law protects innocent victim from harm that was caused by carelessness.